as Gail said, my name is Jim Quitz. I'm a partner and attorney at Morris Hall. I've known Gail for 6 years now, and we've been a happy sponsor of this event since its invention 3 years ago. And it's so exciting to see this momentum and more people showing up, because what Gail does helps what I do in that she starts the conversation. All these little events helps plan, whether it's financial plan or organization or advanced directives or funeral planning. It all makes things that much easier in the most difficult of times. So a little bit about me. I was born and raised in New Jersey. I was married for a while. We bounced around Pennsylvania, Connecticut, and I realized that what I was doing, I was a project manager for first Prudential Insurance Company and then Travelers Insurance Company, wasn't really fulfilling. It was a good job and it had a nice career trajectory, but it just didn't give me the warm and fuzzy. So I had an opportunity to go back to law school. So I went to law school in Phoenix, Arizona Summit School of Law, and didn't really want to reinvent the wheel. I have an accounting and finance project management background, and I want to give back and help people. So I got fortunate enough and started interning with Morris Hall while I was going to law school. So it's like the American dream. I went from intern to partner all within 10 years. So that's pretty awesome. But more importantly, I get to sit down with people each and every day, and I feel like I make a difference. So I don't judge making a difference by the money I could help pass along or the legacies that I help preserve. I judge it by the number of hugs I get. And I get about 1 hug a day. So it has been a really fulfilling career change. Now, Morris Hall is an estate planning law firm. It is all we do. We're located here in Santa Fe, Albuquerque, Las Cruces, as well as throughout Arizona. So Phoenix and Flagstaff and Tucson. So we're covering the whole Midwest. Lisa Wynn is our associate attorney here in New Mexico. So a lot of times I'm not available. They do let me out and go on vacation and stuff. And Lisa is there to help our clients as well. Because you don't hire an individual attorney, you hire the team. Because we all work for the same common objective, making your lives, or more importantly, the people you leave behind, lives a little bit easier. All we do is estate planning. Who here has read the New Mexico Trust Code? How about the New Mexico Probate Code?
Some of it.
A little. Oh, there we go. Then you must have also read the Internal Revenue Code. Anybody else? Internal Revenue? Nobody? Oh, it's so interesting stuff. Well, they're really complicated, and they work together. So we only do estate planning because if we did family law or personal injury, we wouldn't be able to give the best advice possible to our clients and our prospects. So all we do is estate planning. We're also members of the American Academy of Estate Planning Attorneys. This is a national organization that gives our little small firm the feel of a large firm. We can't research everything all the time, so we have resources of this American Academy. Also, we're a very mobile society, so our clients move. We move from California to New Mexico, from New Mexico to Colorado, to New Jersey, Maine, wherever. Well, we have affiliated members in just about every state. So you do a plan here today, you move to Maine, we'll give you a referral to someone out in Maine to help review, make sure your plan still works under Maine law. Also, continuing education. The state bar says, Jim, you have to take 12 hours each and every year of legal education to make sure you stay abreast of all the changes in the law. But I could take a mediation class, I could take a personal injury class, whatever I want or am interested in. The American Academy says, no, that's not enough. That's not helping your clients. You have to take 36 hours, 3 times as much in just estate planning topics. Again, helping ensure that all of our attorneys can give our prospects, our clients, the best advice possible. Okay. Who here has an estate plan?
A will or an estate plan?
Estate plan is the broad topic, so we haven't gotten to the boil down. So well, it's actually pretty good. So 70% of Americans do not have an estate plan at all. All right, so this room is a little bit of above average. That's pretty good. So who's planning with a will as their main vehicle? So a couple of you, okay. And who's planning with a trust? All right, good. And now, who's planning to die? So, right, we're all planning to die. I mean, I think Ron earlier today say, and I've heard Gail say this many times, life is the only thing with 100% mortality rate. So it just boggles my mind when you have 100% sitting here, but 70% of Americans don't plan. Why? What's the disconnect? It's a small group, and most of you have some level of estate plan, so I would rather have this cater to your questions and your needs. I mean, I could talk for hours, and I know I only have an hour, but I could talk for hours, but I'd rather make sure that you guys get what you're looking for. What do you guys hope to learn today, or in the next hour-ish?
She raised her hand.
Trust.
Want to know how we can make changes to our trust, especially because we came from California to New Mexico.
How to make changes to your trust when you, especially moving jurisdictions. Okay, we could cover that for sure.
If you have a trust, can you also have a will?
If you have a trust, can you also have a will? We'll definitely cover that too.
I'm sorry.
Maybe going to the different plans and what each one entails would be helpful.
Knowing what the different types of plans are available and what they could include, sure, definitely. Did you have one? Yeah.
I have a question about IRA trusts and whether you think that they are something worth considering at this point, considering that the Secure Act may do away with the stretch IRA.
IRA trusts, and there's a new bill out there, the Secure Act, that right now is stalled, but looks like it will pass eventually. Yeah, we could hit on that.
I'd actually like to know about the things that most people in the room apparently already know. I'd like to be considered as a beginner, even though my husband and I have a will and a few provisions for our son.
So estate planning 101.
I want some of that.
Estate planning 101. Okay, why don't we start there and we'll incorporate all the questions as we move forward from the 101, so make sure everyone's on the same level. So, 101, what is your estate? What does it consist of?
House.
Property, house,
Money.
good, land, money, stocks, yes.
Retirement funds.
Retirement funds, of course, IRAs, 401ks, 403bs, all that retirement money stuff.
Insurance.
Belongings.
Household belongings, of course, our personal property. Insurance, life insurance, of course. And that's an overlooked one when we're doing, if we get into tax planning, life insurance is one that's overlooked. And we'll talk taxes in a little bit. Yeah, so that is our estate. It's everything we own, everything, our cars, our personal property, the stuff in the house. One thing that's overlooked, and Lisa and I, it means a lot, are animals. Their property, and they have to be planned for just as much as our IRAs and our house and things like that. Who's going to take care of them and as such. So now that we know what an estate is, who here has an estate? Right, everybody does. Everyone has an estate. You know, the panhandler has an estate. His estate's just really, really small. Bill Gates has an estate. His estate is really, really big. And your estate plan has to compensate or deal with whatever your estate consists of. I like to say, I don't care if you're 18 or 118, you need a plan because you have an estate. All right, so what are some of our estate planning options? We've heard a couple, but...
Wills.
Wills. We could plan with the last will.
Trust.
Trust. We could plan with trust.
Life insurance.
Life insurance is an investment, but it is potentially beneficiary designations. We could have beneficiary designations for our estate plan. One of my favorites, and I hear all the time, is I'm going to spend it all. Right? I'm gonna write that last check to the funeral home, and it bounces. Boom. I did my job. I spent it all. What's the problem with that plan?
You don't know when you're gonna die.
We don't know when we're going to die. Right. We might die too soon, and then we have assets or an estate to deal with. Or we might die after we spent it all, and now what? Now we're a ward of the state. So that's not really a great plan. Most of you raise your hand to say you have a will or a trust. If you have no formal plan, you actually in fact have a plan. Everybody has a plan. New Mexico is nice enough to give each and every one of us their plan. It's called the Laws of Intestacy.
What is it
Laws of
called?
what?
Laws of Intestacy. You die intestate. Basically, the statutes tell you who's going to be in charge and who's going to get your stuff. All right? That could be a good plan for you, but I don't know. You know, it's your plan. You need to make sure it works for you. Now, you could do joint tenancy. How many married couples in the room? Okay, so typically we own our real estate or our bank accounts as joint tenants, right? Both names are on it. What joint tenants with rights of survivorship means, and those are magic words. You know, I'm not worried about and or. Those are not magic words. Typically, it's joint tenants with rights of survivorship. When you have a right of survivorship, it means when one of the joint owners dies, the other one automatically gets that asset, that bank account or that house. I do use air quotes on purpose because I hate the word automatic. There's very few things that are automatic in law. So it is one of the few that might be as close to automatic as possible, but yeah. So joint tenancy. Joint tenancy works in that each of the joint owners owns 100% of the asset. So husband and wife own 100% of the asset. Husband dies, because we all know it's always the husband who dies first. Husband dies, wife automatically gets that house, that asset. But how many deaths in a married couple are we planning for? 2, correct? So we have 2 deaths, but joint tenancy only dealt with 1. Aha, wife said this worked so well. It was automatic, and I got the asset. That was pretty easy. I'm going to name my daughter as a joint tenant. So that way when I die, it's going to go to my daughter. Sounds good, right? Estate planning is about risk mitigation. Risk mitigation. I was a project manager, so the difference between an issue and a risk is important. That's what project managers do, is deal with issues and risks. They identify issues. Issues are things you have to deal with. The drapes are on fire. Get the hose. Get the fire extinguisher. It's an issue. I have to deal with it. However, the drapes may catch on fire at any time. That's a risk. Right? It's not on fire now, but it could. So how do we mitigate that risk? Fire retardant paneling. We have fire extinguisher, so you mitigate that risk. So estate planning is risk mitigation. We might have issues, like a special needs beneficiary or something like that's an issue that can be dealt with. But the risk is things don't go the way we plan. So we want to plan to make sure if that happens, it's covered, right? So joint tenancy, we add daughter as the joint tenant. What did I say before? Joint tenant is 100% ownership. So now daughter owns 100% of that property. That bank account, that asset. I'm assuming you're adding her because you trust her, so we don't have to worry about her taking all the money out of the bank account, though she could. What if she gets a divorce? Is your bank account now vulnerable to her divorce? It is. right? Because she owns 100% of it. If she gets sued, is your bank account now vulnerable to that lawsuit, her lawsuit? So you just created, we solved this one problem. Yeah, it's going to pass easily, but we created the risk of these others. What if she's not your only daughter? What if you have 4 kids? She owns 100%, so when you die, she gets it. Is she going to split it with her 3 siblings? Hopefully. Estate planning is not about crossing our fingers and letting the chips fall. It's about planning to make sure things that you want to have happen, happen. So we have some risks. There's some tax issues that happen too. Let's say she does give it to her 3 siblings. Do we know how much you could give away right now in 2019 without having to do any filing with the IRS?
10,000?
You're, I'm going to give you both the prize. We said 10,000.
Well, thank you.
10,000's right, except 15,000 is more right. So 10,000 is the law, but it's indexed for inflation. So this year it's 15,000. So the law actually reads 10,000 indexed for inflation, but it's 15,000. So we could give $15,000 away per person. So a married couple with 1 kid could give away 30,000
Per year?
per year without filing any gift tax returns. Now in that joint tenancy, mom dies, it goes to daughter. Daughter gives that out to her siblings like mom wanted. That's great. Well, if it's a $100,000 account, she's giving more than $15,000. So because it's not a gift from mom at that point, it's a gift from her. So we're creating this gift tax issue by an inadvertent, we're solving this and creating risk and issues over here. Another tax issue is in capital gains tax. When a person dies, we get what's called a step up in cost basis. A step up in cost basis. So that wipes out capital gains tax. For married couples, if you're holding community property, whoever dies, we get a full step up in cost basis, which is a pretty awesome thing, wiping out all capital gains tax. What that means is if we take my little bottle opener, if I bought it for $1,000, that's my cost. That's how much it cost me to acquire. It's my cost basis. Now I have a market. You want to buy for $10,000. That's great. You're going to write me a check for $10,000. I'm going to give you my bottle opener. Or you can answer a question and I'll give you for free. But you're going to give me a check. So I get my check, I give you the bottle opener, I deposit my $10,000. Uncle Sam says, good for you, Jim, you just made $9,000. The difference between the 10 that I sold it for and the 1 that I bought it for, right? That's $9,000 gain. And I have at least a 15% tax on that gain. So $1,350 is going to the IRS. Now Lisa is my executor, and she knew you were going to want to buy this, and I was so excited I got a heart attack and died. Lisa does the sale as my executor. She sells it to you. You write the same check for $10,000 to my estate. Lisa does not have a single penny to pay the IRS. We got to step up in cost basis. So not a $1,000 cost, it gets marked to the current market value of $10,000. Now cost and market are equal, there's no more gain. Same exact transaction, different tax.
Thank you.
So when we gave the gift, when mom added daughter onto the deed or the bank account as a joint tenant, was that a life gift or a death gift?
Life.
A life gift. Mom was alive when she did it, and she gave 100% of it. So only death gifts get that step up. So now, if it was a house, you know, my parents bought their house that I grew up in for like $23,000. And when they finally moved to a retirement community, they sold it for like $350,000. That's a gain, right? The difference. Primary residents have different rules. But daughter does that same sell. She's paying the tax because it's not her primary residence on all that. All because it wasn't planned properly. Okay. So, last wills. a bunch of you have last wills. So do we know what a last will actually is? Those who have one? No? You just said, I trust you, lawyer, I'll sign here.
Most recent?
What do you think a last will does? And I actually learned from Gail that it's not a last will and testament,
That's right.
because we don't have the testament part in our last
No.
wills.
It's your ethical will.
Yes. So a last will are instructions to a judge effective upon your death as to who you want in charge and who gets your stuff. Okay. So last will, instructions to a judge effective upon your death as to who's in charge and who gets your stuff. If I said I want to take you to court, is that a good thing or a bad thing? Jim? Typically a bad thing, right? I'm going to take you to court. It's a bad thing. So what was the first thing I said a will is? Instructions to a, where do judge live? Sit? Court. So wills go to? Court. Did you know that? Do wills go to probate court? Yes. So if our goal is to not go to court, wills don't accomplish that goal. Wills are instructions to a judge. Effective upon death.
May I? Is it not the case that if the executor is not questioned, then it's not going to go to court?
The executor is not
Like,
questioned, it's
so
not going to court.
The executor has the will, everything's good, the family all gets along, the will's instructions are being followed, and it just happens.
That's-
It just
so
happens
that's-
naturally.
What's that? We'll put a pin back.
Okay, that's fine.
It's a good question. Let me get through, because then I'll explain what probate is, and that will answer that question.
Yeah, thank you.
Okay? So we're in probate court, instructions to a judge, effective on death. As far as I could tell, no one's dead yet. So is your will effective right now?
No.
No. So it does you no good. And why would you need a will now? Well, maybe you become incapacitated. If you were here earlier, those advanced directives help you with end of life, but there's that whole period of life before end of life that you might still not be all with it. So your will doesn't help you with that and financial matters. Now, we do get into the good things. You get to pick who your executor is. In New Mexico, it's called a personal representative, but effectively that's an executor. You get to choose whoever you want. Okay? You get to choose if they pay a bond or no bond or whatever. You get to choose. And then who gets your stuff? You know, do you want to leave it to charity, or do you want to leave it to your kids, or you want to leave it to your neighbor, whoever you want to leave it to? And that goes down that way. So what a will does is goes to court for all these decisions to be made. So what probate court actually is, if we really boil it down to its bare minimum nub, it's a court process that moves assets from dead people to living people. There is no executor until the court says there's an executor. So you have to open a probate to become an executor or a personal representative. The way you think about this. So I said Lisa's my executor, my personal representative. I pass away. I bank with Bank of the West. And she goes to the bank and says, Jim died, here's his death certificate. And here's his will. And his account number is 1234. Give me the money so I could pay his final bills. And then distribute to his beneficiaries. Bank of the West is going to say, no. You're nobody. I don't care that you have a will. I don't care that you have a death certificate. I don't care that you have his account number. It doesn't mean anything. Give me a letter from the court. It's called a letter testamentary. It's the power to access the money. You can't access the money without having the court involved. Now, a lot of the other issues go away when the family gets along and everything. The minimum you could close a case, a probate here, informally is 6 months. You have to keep it open 6 months. I don't see it closing that quickly anyway, so that, I mean, the law's kind of moot if you're doing it right. There's like 26 forms or process steps to get through the probate properly. Anytime you cut a corner, you create the risk that something's going to come back and bite you later. Personal representative is a fiduciary to honor what the decedent wanted to have happen. You can't change your mind. Well, Johnny didn't go to the funeral, so he shouldn't get as much. Well, if it doesn't say that in the will, it doesn't matter what you think. You have to do what the will says. You're a fiduciary. And you create risk when you don't follow it, that someone's going to come back. We had a case where we weren't supposed to go to probate, but we knew there was going to be contention, and we don't do contests. Lisa and I don't like going to court. We don't like going, we plan ahead so we don't have to go to court. But we knew this one was going to be a problem, so when the grandfather died, we referred the trustee to another attorney in anticipation that there will be a fight. The kids were disinherited. So anytime you disinherit someone, there's more chance of a fight. Well, it was going smoothly until they found this one piece of property that didn't get transferred into the trust name. That's how we avoid probate. So they opened a probate in Bernalillo County, and all of a sudden the kids start to contest. And that was 3 years ago. The land was only worth $1,000.
Oh, jeez.
I don't know why they opened the probate for a $1,000 piece of land, but it would have been no problem otherwise. Court creates the risk. Not every probate is bad, but it has the risk to become bad. I had a client up here whose husband passed away. We had to open a probate. They didn't fully fund the trust. And I mean, the name was like John F. Smith was the decedent. Well, a creditor said John Smith owed me money. Well, after months of fighting and arguing, turned out it was John W. Smith, not John F. Smith, or something similar. Again, probate just creates the risk that something could happen. The average cost in a probate in New Mexico is 5.5% of the estate value.
Wow.
That's on average. What do we know about averages? There's higher and there's lower, but on average. That covers attorney's fees, court costs, any tax filings. That's just the cost that depletes the estate. I got a call from a prospect the other day, and he's up in Colorado. He said, oh, my dad's estate is just finishing up, and the personal representative is taking 7.5%. Is that normal? I don't know. What work did he do? I can't say. On average it's 5.5%, but again, it could be higher or lower. It just has to be reasonable. New Mexico does not have a statutory, you get 4% or 1% or whatever. There's no statutory requirements except that it has to be a reasonable fee based on the amount of work you do.
You said the 5.5% includes all the probate court expenses, hiring an estate attorney.
The 5.5% is all inclusive of all the costs typically involved in
And who gets that again?
Who gets the cost? The court, which is the state, the attorneys.
Court collects it?
It's all the different, whoever does the work collects it. The attorney's going to collect his or her portion, the courts get their portion, the appraisals get their portion, so that's just on average.
My mother lives in Peru. She's not a resident of the United States, but my dad and her have an account in the United States with a bank. My dad's English, so where my dad gets his pension. But my dad's passed away, and so now that account is just in my mom's name. So if when something does happen to my mom, so the court, for my brother and I to prove that we are her children, if there were anything left in that account, we would have to go through the courts and all that.
If there's money left in an account, we do have, so if there's money left in an account in just mom's name because dad has already passed, you need to show proof of authority that you get that account upon mom's passing. The typical approach is to get the letter of testamentary authorization from the court. New Mexico has a law that says not every estate has to go to court. Small estates, anything under $50,000 that doesn't involve real estate, can be collected via an affidavit. I swear it's under 50,000 to swear. So if it's small enough, then you don't have to go to court. So like the panhandler won't have to go to court to get his stuff to his next of kin. He has less than $50,000. So it just depends on the
So
size
we
of the
just
account.
have to prove that we are her legitimate children.
You just have to prove that you are the rightful
Through a
heirs,
birth-
if you will,
a birth
to-
certificate.
correct. So one of the things when we do estate planning, and I kind of mentioned it, it's, you know, we all come here thinking estate planning is death planning, but estate planning is really legal planning too. Earlier session they mentioned Who Guards the Guardians, an expose piece the Albuquerque Journal did in 2016. If you haven't read it, I highly recommend it, and there's a town hall video on, or maybe it's just audio, but the town hall is just as interesting as the expose. Who Guards the Guardians? It was in the Albuquerque Journal, but it talks about guardianships and conservatorships. So guardianships are power over the person, conservatorships are power over the money. So when you don't have a formal estate plan where you're identifying who has the power, then you end up in these guardianships and conservatorships. The basic gist of this article was this $5 million estate. When the woman, mom, ultimately passed away, the estate was worth, I think, like $700,000. Like, so it got depleted over the years. Now, I will, hedge that a little. We write to get readers, so it's slanted a little bit. So I don't think it was as bad as it made it out to be, but it definitely wasn't good, right? So planning could have been avoided. By planning, a lot of the issues could have been avoided. So highly recommend Who Guards the Guardians, Albuquerque Journal. I think it was November of 2016 when it actually came out, but there was a town hall several months later. In fact, the legislature has changed the law on the reporting and accounting access. So one of the issues in the article was the family kept asking for information. Why, how come it's depleting, and where's the money? And the court said you can't get that information; it's sealed, which makes sense because the number one culprit of elder abuse is typically the kids. The family is typically your worst enemy. So the laws were set up to protect the ward, the person who's incapacitated, from further abuse of the family. Well, now it's open. The new law says it's access. You can get information, which it just swings the pendulum the other way. So maybe over time it will figure itself what the right level of reporting is, because you don't want the depletion to happen, but you still, mom needed care, so home care is not cheap. So there's going to be natural depletion anyway to make sure mom stays well. So another option is a revocable trust. Now, trust, the word trust is a 30,000-foot term, and it's important to realize that. So the equivalent would be sports. If I asked you what the rules of sports are, can you tell me? What do you need to know? What sport? Can you tell me the rules of trusts? No, you have to say which kind of trust. Okay? Not all trusts are the same. There's grats and cruts and eyelets and idiots and cuperts, and irrevocable trust and revocable trust. So a basic estate planning tool for most people is a revocable trust. Revocable trust. Revocable means you could change it. Okay? So life changes and ebbs and flows. We recommend our clients come to see us every 3 years. Laws don't change all that fast. Life doesn't change all that fast. But that way you can make sure when the time comes to use the plan, it still does what you say it does. I wrote my parents' estate plan. They still live in New Jersey, but they have a house in Arizona. So we made an Arizona trust. I'm licensed in Arizona. Actually, we're both licensed in Arizona and New Mexico. So we did an Arizona trust. And I tell this story, picking the right trustee, you don't have to be local. It's skill set. I have the skill set to be a trustee and executor. This is what I do. My brother who lives near them is their healthcare agent or proxy. Well, it makes sense. He lives near them, so he'll get to the hospital first. And so I tell this story all this time. Well, I did their review earlier this year, and it turns out I am not the executor. It's my brother who lives in New Jersey. So reviewing your plan is important because you start to think what's in it, and then you start to believe what you think is in it, and then it turns out that's not what's actually in it. When we review plans, we talk to clients all the time, and oh yeah, you're giving $10,000 to the church, and you name the church, and they're like, oh, I haven't been to that church in 20 years. I don't want to do that. So it's reviewing is important. The goal when you plan with a revocable trust is to make your assets go to zero. Remember what probate is? The court process to move assets from dead people to living people, or incapacitated people to people with capacity. Right? Well, if you have no money, there's nothing for the probate courts to do. That's how the trust works. You move all the assets from your name or your joint names with your spouse into your trust name. Okay? So that's called funding the trust. Funding the trust is the most important aspect because no matter how well that trust is written, if there's no assets named in it, titled in it, it does no good. Now you do get a will when you plan with a trust. It's known as a pour-over will, so you can have both, and you should have both. The pour-over will is a safety net. A safety net. It catches anything you forgot. When my mom and dad were doing their estate plan, my mom does most of the finances, that's why I gravitate to her only, but she was talking to me and our financial advisor, and they're going over, okay, we gotta get that into the trust name and all this. And all of a sudden he's like, the financial advisor's like, is there anything else? Are you sure? And my mom and she forgot about a $20,000 bank account near where she used to work because it was convenient back when you had to go to the ATM all the time to get money out while she was at work. She totally forgot about it. Had she not remembered in that moment and my mom and dad passed away, they would have had a probate to move that asset, distribute the pour-over will, would move it into the trust, pour it from their account for their names into the trust name. That's why it's a pour-over will. We hope we don't use it. If we're planning with a trust, we don't want to use the will because wills go to court. And typically if you're planning with a trust, you're trying to avoid going to court. But it's there just in case. Okay? So funding the trust is ultimately very important. When you go to the bank, and you go up to the teller, and you tell the teller, I want $100 for my account, and my account number is 1234. Are they going to give you $100?
New Mexico.
What else do you have to tell them before they give you $100?
Verify who you say you are.
Verify who you are, your ID, exactly, right? So if I knew your account number, and I knew you banked with Wells Fargo, and I go to Wells Fargo and say, I need $100 from account 1234. Why will they not give me that money? Because my name is not on that account. That's the same thing with funding the trust. We know that account or that property or that asset is in the trust by the name on the account. So if I go to the bank and it says Jim Plitz, my trust has nothing to do with that. But if it says Plitz Living Trust, then we know the terms of that trust control that account. Now, most of the time when I tell people that they have no money, because it's on the trust, it freaks them out. Really, you have to think about it like it's control. Who controls that trust? So you have to look at the three positions in a trust. Position one is the trustor. That's the person or people who made the trust. Your trustor.
Trustor.
Yes. The trustor moved their money into the trust. They made the trust. In your trust, you would be your own trustor. The other position is trustee. That's the manager of the trust. The manager of the trust decides what to invest in, what to buy, what to sell, what bills to pay. The trustee does all that. Okay? You, in your revocable trust, would be your own trustee. Married couples, you would be co-trustees. It would be both of you as trustees. So you'd be managers of the trust. The best position is the third position. That's the beneficiary. So all the money, all the assets in the trust are for the benefit of the beneficiary, the spender of the money. Okay? In your revocable trust, as long as you're alive, you will be the beneficiary. So you made the trust, you manage the trust, you spend your money. Do you manage your money now? Do you spend your money now? Yes. So the living trust, the revocable trust, does no difference than what you do today, but now we're starting to mitigate the risks of an incapacity and the risk of ultimately dying. We have it planned out. Now you'll have successor trustees, people to step in when you can't. Married couples, obviously, it would be after the two of you. So if you both get in a car accident and you're in a coma, your successor trustee steps in to manage the trust. Since you're in a coma, you're still alive. So the money's still for your benefit. The trustee manages for your benefit. Now you'll also have contingent beneficiaries. People who will be the beneficiaries when you're no longer alive. That's what we traditionally think are the beneficiaries, right? Our kids, our loved ones, whoever we want to see to benefit from our hard work and what we leave behind. Okay. Now we can set the trust up in a whole bunch of different ways. If we're worried about asset protection, lawsuits, divorce, bankruptcy, we could set it up to protect them. If we need to set it up because you have a special needs beneficiary, we could set it up to protect them and the government assistance that they get. When Lisa and I review trust and we see, you have 4 kids, but in your existing trust or will, you're only leaving it to 3 of them, our natural question is, oh, you don't like your 4th child? And more often than not, they say, no, we love him a lot, but he's on Medicaid, and he can't get an inheritance. So the one that actually could use the money the most, you're disinheriting. Why don't you just plan for it? That's what we do. We plan to cover that. That's an issue. It's a problem that happens now. So we plan for that with a special needs trust. So we could plan for things. We could put pet provisions in. If you want to leave money for your animals, what does that mean? How does that work? And we could help with that. So we could plan for all these things. My son is 9 years old. He can't inherit. He would have a conservatorship over the money if I didn't plan properly for him, if I was to pass before he turned 18. And 18 is not, he's not inheriting at 18, forget that. Think about when you were 18. Think about it, and now give yourself a $200,000 inheritance. What's happening with that money? It's gone. He's got it. So my trust says he can't, if I pass away and he's not 35 yet, he has no control over that money. Someone else, another trustee, will be in charge of it. Now it's there for his benefit. So it could pay for school or clothes. It could help him buy a house or a car. But he's not getting the Porsche. He's going to get the used Civic. Right? It's about who's controlling it. So we can plan for that. Now my trust is revocable. So once he becomes a Rhodes Scholar and I know he's good at age 22, 23, I'll change my trust. But until then, he could wait till 35 to have control.
What's that called? When, let's say, like an immature recipient, whether it's by age or personality, what kind of a beneficiary is that?
Well, technically it's an incapacitated beneficiary, but yeah, I mean, it's just planning, the way we plan to mitigate that risk, whether it's a spendthrift or the risk of outside factors such as a lawsuit or a divorce, we continue the trust post-death. It just changes from a revocable trust to an irrevocable trust. So the trust just continues on for the beneficiaries. And it could be broken up. If I had 5 kids, when I pass, I could have 5 separate trusts to hold each of their 20%. So we set up, it's about what you want to have happen. When I was a project manager, the business had the business ideas and the information technology, the computer people would implement it, right? And design it. And my job was in the middle to kind of liaison between. And if the funniest thing would always happen, the business people said, this is the computer system I need. And the computer people would say, this is the direction you should take the business. And I'm sitting there, no, that's wrong. You guys, you business people should say what direction you go. And the computer people should say, this is how we could help get there. The prospect, the client's goal, you need to tell me what your goals are. Our job is to find the most efficient and effective way to achieve those goals, as well as make sure you understand all the risks associated with it. We love these kind of events because we get to educate and make sure that when you make decisions, you're making an educated decision. Because that, to us, is the most important thing. You want to have your plan work when you need it. When you're doing any kind of estate planning, it's not about you guys, ultimately. Because the incapacitated person or the dead person doesn't know any better. It's about everybody you leave behind. We say, who should do an estate plan? Well, if you have more than $50,000, because then you are above the statutory threshold. But what's more important is if you care about anybody. Because if you don't care, why do it? It takes a lot of time to do, a lot of thought, emotional currency, because you're thinking about incapacity and death. They're not easy topics. It takes actual time if you're doing a trust to move assets into it. It takes time with the attorneys to make sure it's drafted right and reviewed and everything. And then it has an actual cost. So it's money that you aren't spending on a vacation, you're spending on your estate plan. But if you care, that's why you do it. Because if you didn't care, just let the chips fall. IRA trust. So it's an advanced trust. So IRAs are super complicated. We think they're not. But IRAs are super complicated. Each year, this attorney / CPA sends out a chart, and that we all use. He's up in Milwaukee, but the flow chart of an IRA decision path is mind-boggling, all the different permutations that you can take, because of the two aspects of an IRA. So we're talking traditional IRA, not Roth IRA. But so when we're talking a traditional IRA, and I'll lump in 401ks and 403bs and 457s, I'll just call them IRAs. But we have the income tax issue. So anyone taking required minimum distributions yet? Okay. Right, you pay tax when you take it out, and you pay tax on what you take out, right? So there's always income tax. So when we're thinking about when we leave it to our beneficiaries, and you have, let's say, I'm going to make a big number, you have $1 million IRA and you leave it to your beneficiary, are they getting $1 million? Well, not really. It's going to be somewhere between $700,000 and $800,000 depending on their tax rate, because there's that built-in tax that's in there. So income tax is always an issue, and that's where the Secure Act comes in. The other issue is asset protection. Now, the good thing with IRAs, there's laws both in ERISA, federal, and New Mexico that say you could protect up to $1 million. So if you went bankrupt or got sued, your IRA is protected up to $1 million. That's good. For married couples, when your spouse inherits your IRA, you get the same protection. The government has a compelling state interest to keep your retirement secure. So that's awesome. But in 2014, the Supreme Court ruled that non-spousal inherited IRAs, meaning when it does get to the kids, no longer asset protected, because the state doesn't have an interest in an inheritance. And that's how they viewed it. The tax doesn't go away, but now it's an inheritance, not the kid's retirement. When you're planning with an IRA trust, so that's just a different vehicle that works alongside your revocable trust. Remember I said there's a whole bunch of different kinds of trusts? IRA trust is a separate type of trust. The good thing with IRA trusts are it's dealing with only the one asset. So one of the rules with IRAs is you have to give your trust to the custodian, to the Charles Schwab or Fidelity of the world on the death. Well, if your trust deals with all your assets, your house and your bank accounts and your IRAs, you're giving them more information than they need, but that's the rule. When you have an IRA trust, you're only giving them that one portion. Now, the other part is with a properly drafted IRA trust, you're adding that asset protection back in. So when the kids inherit, they get it through the beneficiary trust that I was talking about with the revocable trust, a whole bunch of different trusts, I know. But you could protect it. Whether the Secure Act passes or not, so what the Secure Act is, right now, your RMDs are based on life expectancy. All right, when your grandkids inherit, they're not 7.5, but they will have to still take required minimum distributions based on their life expectancy. Well, their life expectancy just happens to be that much longer, so what they have to take out each year is less. What the Secure Act is pushing the RMD age to 71.5, so it's moving it up. It might be 72.5. Anyway, it's pushing it further into our life. But the bad part is when the beneficiaries inherit, they're saying you have to take it out in 10 years. Now there's some carve-outs for grandkids and special needs and things. But instead of stretching over life expectancy, you have to take that entire IRA out in 10 years. Which means you're paying tax at a quicker rate. So that's why the government's doing it, because they want their tax. They don't want to stretch it over a life expectancy. So the IRA trust is still a useful tool because it is a standalone asset, and it still adds back the asset protection. It just doesn't do any good if the Secure Act, it doesn't help. The current IRA trust won't help with the stretch any differently, but the Secure Act will just truncate how you have to pull it out at that time. Okay. All right, any other questions? Did I cover everyone's question?
We're stunned in silence.
Deer in headlight.
I have a question. Okay, let's say that you have money in the bank, but you haven't done a will or a trust or any of these other things that you must do. What's the best way to handle that if you want your children to have access to those funds of the bank?
If you haven't done your estate plan yet, come see Lisa or I and get your estate plan done. Anytime we do shortcuts, you solve issues, but create other risks, right? That's what we're talking about with the joint tenancies. I mean, you could add your kids to the account, but now it's their money, and you lose control. You lose the step up if it's stock, bank account, not a big deal, but it becomes vulnerable to their issues. Whereas if you just do proper estate planning, we don't have the risk. They could still get access to it when the time is needed, but you eliminate the risks of everything else. So,
like what? Risks like what? Like
lost, if your kid got divorced, or if your kid gets sued, they're on the account. It's their money.
Right.
So it doesn't matter that we pretend. I had a client up here, mom and daughter, they moved in together, daughter was still working, so majority of the assets were hers, but they put both names on everything because they figured if one passed, it would just go to the other one.
Right.
And then mom got sick and needed nursing care, and the place was like $500, $700 a month. And she didn't have the income to support that, and daughter didn't really have the income to support her life and that, so she needed to apply for Medicaid, but she couldn't because she was on all of daughter's accounts because it was her money. So she had to hire me to help get through that issue. Had they just did proper estate planning up front, it would have been a lot smoother. Mom would have had no money on day one and been able to qualify for Medicaid. So it's risk. We don't think it's going to happen. A real quick story, because all day we hear stories, and the good and the bad, but we hear stories, and our human minds want to hear what we already know. We want confirmation. confirmation bias. So if I hear what I already know, yes, I'm right. But if I hear what I didn't know or don't really believe, it doesn't matter, right? So I broke my nose in June. And it was on a Monday night, and I have pictures if you really want to see it. But my nose was like way over here. And on Thursday, I got to see the ear, nose, and throat doctor, and she said, yep, your nose is broken. I'm like, all right, I got that. But she's like, it's good, you saw me soon enough, we could get you in a week, you know, you want to get it corrected within 12 days because it will set and they would have to re-break it if it's beyond that. I said, oh, that's great, except I'm going to Iceland in a week. So she calls around to see if there's anyone available, and she's like, no one's available. However, there's this one guy who's in town today. You could see him this afternoon if you want. The only thing is, he doesn't use anesthesia. So I'm like, I'm going to Iceland. I can't go to Iceland with my nose to the side. So I took the appointment, and they stick this huge needle up your nostril to numb it, and I definitely use air quotes because it didn't numb. And then he took this instrument that I describe as a butter knife and puts it in my nose, and I see all the muscles flex in his forearm, and he pulls my nose, and then does the other nostril and pulls it again. And I'm crying, and one of my buddies said, oh yeah, when you hit your nose, it's reflexive crying. I'm like, yes, that's it. It was reflexive crying. I wasn't really crying. And then he looks, and he's like, I could get it straighter. And I said, okay, do it. And he pulled it again, I'm crying, and it was terrible. And so having said that and experienced that, I will tell you, if you ever break your nose, get the anesthesia.
And skin isolation.
Yes. It's, that kind of story resonates. You could take my pain, you could feel the pain, and that would stick. But the stories about problems or the risks, they don't resonate. And so it's just interesting because we hear stories. Gail has stories, and we hear stories on what happens when we don't plan, if we don't have advance directives, if we don't have a will or a trust. But it's never me. It's not us. You know, my kids won't divorce. They won't get sued. I hope so. That's the goal. But without planning, we don't know.
I'm puzzled about the term IRA trust, because is that like a trust that your IRA goes into after you die? Or because you can, when you have an IRA, you have, your spouse is the first one to inherit, and then you have the secondary successors or whatever. And if you have two kids on there, wouldn't they just each get half and then have to use it within 10 years? Or have to withdraw it within 10 years?
So I don't think I could repeat that whole question. So what an IRA trust is a separate standalone trust. It gets funded, or the IRA moves into it after, for a single person, the first person to die. So what you have this IRA, we'll do a single person. IRA, the beneficiary of your IRA becomes your IRA trust. So when you die, it pays into the trust. Now, whether you have 1 kid or 5 kids or 2 kids, the trust then divvies it up. The nice thing with that is that trust only deals with that one asset. It adds the asset protection components to the kids, which protects the IRAs, which we just learned in 2014, IRAs are not protected anymore, or inherited IRAs. It also has all the contingencies, right? When we name our kids as beneficiaries, a lot of times we don't. There is no what if my son dies or what if my daughter dies. Where does that go? We end up thinking we have a non-probate transfer, the beneficiary designation. But if your beneficiary is deceased, you end up in probate anyway. Well, your trust, when it's written right, says it's going to go to my 2 kids. Well, if 1 kid passes, that 50% goes to his kids. And if they don't have kids, maybe it all goes to my other kid. And so all the what ifs are covered in the trust. But it is only funded. So married couples, yes, name your spouse as primary beneficiary. That has the tax advantage, asset protection advantages. But if we're planning with an IRA trust separately, then you name the IRA trust as the contingent beneficiary.
May I? I know you're running out of time. So,
2 more questions.
okay, so in New Mexico in particular, but all over the place, a lot of us or our neighbors are lucky to die with $60,000 in the bank and maybe a low-value house. But it sounds like these are the folks who still need to have an estate and yet can probably least afford the services to get that set up properly. So what is the simplest estate that someone, for example, like Gail, could advise a client like that, how they can, like, how, without cutting the corners, without running into the risks of taking shortcuts, without trying to sneak it past the tax man, what do we do for our neighbors who never had an IRA and never had the 401k and are just really cutting that edge of, I need an estate, but I can't do it?
I am not an attorney, I don't provide advice.
Who would
Talk
you send
to
them
Jim.
And this is so many of us in New Mexico.
So when your estate is modest to
Yes.
small, the issues become bigger, right? Because Bill Gates could afford attorneys. So, he pays $350 an hour, the same as the person with $60,000 in the bank,
Yes.
except $350 an hour to the $60,000 person is going to hurt that much more. So, it's finding the right attorney. Typically, solo practitioners tend to be less expensive than firms, just overhead, and they are only affecting themselves with what price they charge. New Mexico does have transfer on death deed opportunity, so it doesn't help with the incapacity, but at least on a death, it could go to.
That would be the title, not the bank account.
Correct.
Yeah.
With bank accounts, you can put beneficiary designations on typically. Again, there are, all the other risks are out there, and so it's for that client to weigh, do I pay more upfront and reduce the risk? It's insurance, right? I mean, auto insurance, we all have auto insurance. I'm going to guess most of us don't have the state minimum. We actually have more because we want to pay for the peace of mind to know that if I actually get in a car accident, I am covered and that other person's covered and I'm not going to lose everything I've earned. So it's a tough balance. I mean, Lisa and I were talking at lunch, and one of my clients' sons went bankrupt in Florida. He was inheriting $50,000, so it's not changing his life, but coming out of bankruptcy it was. And obviously we didn't know when we were planning his dad's estate that his son was going to go bankrupt. But because that's how he planned, and bankruptcy law says well, after the bankruptcy closes, they have 6 months to reopen. So when they learned dad died, they knew the inheritance was coming, they reopened the bankruptcy. Well, it was protected because we planned properly. So it's always tough, do we cut a corner and say we'll just do transfer on death deed? Well, then that one bad thing happens and we don't know. So solo practitioners, everyone should have a power of attorney, and the healthcare directives, doesn't matter, those are all super important. And then there are other, you could cut corners, but then know that those risks exist. And if that's okay, that's okay. You make your educated decision. Or if you want to pay to mitigate the risks, that's what you do.
Thank you.
So does your firm do, obviously you do estate planning documents, and you do probate and all that?
We do the estate planning documents ahead of time. We do trust administration and probate. We don't do litigated matters. So when there's fighting, we could send a stern letter, but beyond that, we look for litigators.
I was just going to ask him, regarding her question, what about just doing a will? Would that just help and be less expensive?
It's, when we're just doing the will, again, it's less expensive up front, but if you look at the life, then you're going to court after death. And so the expense arises. So when do you want to, where do you want to pay? You know, planning with a trust is more expensive up front, but could be as low as 0 on death, where a will is less expensive up front, but again, the average is 5.5%. Like, our minimum fee for probate, an uncontested probate, is $8,500. So, you know, so someone's going to get paid at some point. Just where do you want to deal with it?
What an education!
Yeah.
Yes. That's very good.
Thank you.
Thank you, guys.